Good morning and welcome to the fifth meeting of 2025 of the SPCB Supported Bodies Landscape Review Committee. I have received no apologies for today's meeting. Today the committee will take evidence from the Scottish Human Rights Commission and then from the Children and Young People's Commissioner Scotland. And I'm grateful to welcome today to committee, first of all, Professor Angela O'Hagan, Chair of the Scottish Human Rights Commission, and Jan Savage, Executive Director. Welcome and thank you for being with us. We'll move directly to questions, and similarly to the other commissioners that we've had before us in recent weeks, I'm going to start off with quite a general question, which is, what do you consider to be the purpose of the Scottish Human Rights Commissioner, and how does this differ from the role of ministers, MSPs and other bodies? Of course, as MSPs, we have our own experience and understanding of that, but I think it's helpful for context to just allow you to set that out in the first instance.
Thank you. Thank you very much, Convener. Good morning, everyone. Well, the purpose of the Scottish Human Rights Commission is to serve the people of Scotland in the realisation of their rights. We were established by an Act of the Scottish Parliament in 2006. We're independent of Parliament. We have a general duty to promote awareness, understanding and respect for all human rights. We're independent of government, and so we differ from government in a number of ways. As an A-listed national human rights institution, we are bound by what's called the Paris Principles, which are a set of principles to which all national human rights institutions are bound. And that requires us to deliver a broad mandate on rights realisation. We're not bound by political party allegiance or manifesto commitment. Or contained, if you like, by the impartiality of the civil service. We provide advice to government, to Parliament and to others based on interpretation of the relevant domestic and international human rights standards. And we're focused on the realisation of rights for individuals and adherence to the international human rights obligations of duty bearers, public service, public bodies. And our staff team have a different type of expertise, different level of expertise from government and parliamentary officials. There's a deep specialism across rights domains. And we work to the structures and processes of the international human rights framework. Our purpose was established under the Act. Our purpose, structure and function and resourcing levels, in common with all the office holders created by the Parliament, are different from one another. We don't share the same structure. We are a commission with a chair and 4 members of the commission. And as such, we have that additional level of governance within the commission as well. So coming back to our purpose is to promote awareness, raise awareness of rights, but ultimately to without fear or favour, to encourage individuals to come forward, to uphold their own rights, to defend their rights, but for Parliament and others to hold to account the duty bearers in ensuring that their obligations are effectively discharged and their conduct and in relation to their human rights obligations are effectively scrutinised.
Yeah, I mean, thank you. That's very helpful. And I noted in your written submission of the 13th of February, you stated that it's to do with a persistent lack of access to justice at an individual and systematic level. I thought that was quite a good phrasing, encapsulating some of my experience of the work you do. I mean, in that space, I mean, how do you perceive the current role of the SPCB supported bodies, including yourselves, of enhancing public trust and confidence in public life in Scotland?
I think in relation to access to justice and what we perceive to be systemic rights failures, in which we have evidence in our recent research series around the Spotlight reports on, for example, institutionalised care and the length of time that people are detained effectively in inappropriate care settings, what we've reviewed and revealed in places of detention, and our recent report on economic, social and cultural rights in the Highlands and Islands. All of these demonstrate the systemic rights failures that you're talking about. And what they're doing is bringing into the public domain the realities of rights in people's everyday lives. And that, bringing that into sharp focus, and in the way that we work through a very participatory way of working with human rights defenders, with people who have direct experience, whether that's of the care sector or excuse me, of detention or fatal accident inquiries, etc. So working directly with and through those human rights defenders and people's own lived experience also is a way of demonstrating our openness. Our participation is rooted in, our approach to participation rather, is rooted in a fundamental belief in the Commission that that's the most effective way of working. It's clearly stated in our strategic plan, where we say there's a very strong quote in our strategic plan which is about recognising the humanity of the person standing beside you. And that openness and engagement is what builds trust, as well as a very robust governance structure within the Commission, and I'm sure we'll touch on that later, so I won't go into the detail on that just now. But openness to engage, we have not just a requirement but a desire to function as a pluralist organisation. That's a requirement of human rights, so we do engage in a range of perspectives and formulate advice and engagement based on interpretation of the international human rights standards, but always focused on securing the everyday rights of everyone in Scotland, from the basic foundational principles that everyone has a right to be treated with dignity and respect, and that applies in all aspects and all domains of individuals' lives, which means then that touches on every aspect of public policy.
Now, of course, the realisation of rights is fundamental in all of that, to make sure that it's not just written in law but understood in people's everyday lives. And certainly my interaction with you in a constituency perspective, for example, in housing in Leith, a number of council housing blocks in Leith you've been engaged in. And the reason I mention that is because you talked about your recent work from last month around the institutionalisation of independent living in Scotland. I've mentioned housing. Both of these areas are partly also in the consideration of the Ombudsman as subject areas. Parts of the health service, local authority, housing delivery and housing associations we heard in previous evidence. So I just wondered if you wanted to say anything about your work and its differentiation from the Ombudsman and any collaboration that you do, and then I'll turn to Murdo Fraser to ask further in this area.
Sure. I mean, two main points within that. The Scottish Public Service Ombudsman is mainly a complaints function in the areas that you've described, whereas our role is completely different in terms of framing inquiry, research, advice from a human rights framework, empowering individuals through the promotion and raising awareness of their rights, to frame their rights in their engagement with public authorities in relation to whether it's housing or the provision of care. And you asked about collaboration. We do have a very effective working relationship indeed with all the office holders as appropriate within different different operational and strategic interests. The Scottish Public Services Ombudsman has been working on a rights-based complaints process, and separately we have an operational arrangement or relationship rather with the SPSO in relation to shared services. But I don't know, Jan, if there's anything you want to come in on. If I can, if that's okay, just in respect of those,
Sure.
those two issues, and perhaps most recently the deinstitutionalisation project. As Angela said, the role of the Public Services Ombudsman in that space is to take on individual complaints, and one of the challenges we have is we don't really know how many individual complaints will make their way through to the Public Services Ombudsman from individuals who are in institutions or family members who are advocating on their behalf. And there will be lots of reasons that there will be a lot of people who don't even have the wherewithal or the means to make those complaints to the Public Services Ombudsman. And so the role of the Human Rights Commission, which is quite distinct there, is to take a bigger systemic look at that, look at the available data, and to, without fear or favour or judgment, report on the situation as is, as being experienced by individuals through the Human Rights Framework. And in that case, it was Article 19 of the UN Convention on the Rights of Disabled People, and assess that reality through that lived experience and the best available data we have against that international human rights framework, against then the policy initiatives and investment that Scottish Government and public bodies have rightly tried to progress matters, and report that unfortunately there's systemic failures in upholding those human rights. And so that's the difference. Other public bodies absolutely have the role to investigate at individual level and seek remedy and redress for individuals. But at systemic level, the Human Rights Commission and bodies like us have the opportunity to step in and then to provide you as the Parliament and ultimate guarantors of everyone's human rights with that evidence in order that you might be able to interrogate that further. So
that's very helpful for our considerations to just get those differences on record. So I'm now going to turn to my colleague Murdo Fraser.
Thank you. Good morning to the panel. Welcome. The mandate we've been given as a committee by the FPAC committee is to look really at two broad areas. One is whether there's any gaps or overlaps between the work of existing commissioners, and secondly, proposals which are in the pipeline, which you'll be aware of, to create new commissioners. So I'd like to explore these issues more or less together, if I can, because I think there is obviously some synergy between them. We've got in the pipeline proposals for a commissioner for the disabled, a commissioner for older people. We already have a commissioner for young people. I suppose my question in simple terms is there any reason why the work you're doing can't encompass the work that is being proposed or already done in terms of these, what you might call sectional groups?
Certainly, I'll perhaps start on the basis of work that the Commission had instigated last year in 2023 in a paper called At a Crossroads, so what next for the human rights system in Scotland. And it was really trying to grapple with exactly that question. So seeing that there was an emergent trend of advocacy for new public bodies to uphold the human rights of particular groups of people. And in our view, rightly so, there are clearly failures at systemic level for so many, far too many groups of individuals. There's no doubt about that. In the case of disabled people, we've just talked about an example of the Human Rights Commission's own evidence now, which would bear witness to that. So from the Human Rights Commission's perspective, we wanted to raise the profile of the reason for this, and the reason for this is systemic and persistent failure around access to justice for individual groups, no doubt about it. The question that we also sought to grapple with, though, is what's the best route through that, and it's ultimately not for the Commission or for any one of us to say whether there should be more commissions or not. But the question you've asked is there potential for a body like the Human Rights Commission to do more for those groups of people? And we've set out in that paper, and we've said in various evidence papers into the Scottish Parliament that yes, there is, and there are different models through which that could be achieved. There are models such as rapporteurship models, so that may be taking, for example, per Human Rights Treaty, CEDAW, CRPD, ISESCA and so forth, and creating dedicated monitoring groups in the Commission's team that had a permanent focus on the rights of those people. You can look at other international models where you have perhaps a broader number of members of the Commission. As Angela said, we currently can have 1 chair and up to 4 members of the Commission, and none of those members are appointed by Parliament on the basis of to represent the interests of a particular group of rights holders. So it's pluralist in a different way. But there are international models where it's a bit different, and Parliaments can decide to appoint commissioners who have the responsibility to represent particular groups, and that has to be supported by a team of people who can monitor and provide support. And then finally, regardless of all of those models, there is the need, we believe, to look fundamentally again at the mandate of the Commission and its enabling powers and the tools that it has available to it to uphold human rights for everybody. But they're the three routes that we believe further consideration could be given to extending the coverage and relevance of the Commission to those groups of people.
Thank you. I've almost got my voice back. Sorry, I've come with a horrible cold. I hope not to smit you all. And Jan's absolutely right in terms of some of the, you asked the question, Mr Fraser, about gaps. There are clearly gaps in our mandate, and the Commission has articulated them very clearly over a number of years, and they've also been highlighted in the international accreditation process as well, to which we are also subject, and we're about to embark on our next cycle of re-accreditation. And it relates to Mr Macpherson's question about systemic failures. And so in our paper at A Crossroads, we kind of took that head on to say part of the reason that there are these calls for additional commissioners is because people's rights are not being realised. And that's a matter of policy, policy implementation, policy choices and resourcing allocation. There's also a question within your question about new commissioners in terms of the criteria. And on what basis should any new commissioners or new entities be created? The Scottish Parliament has had its reasons for creating the office holders it has in the past, and there's the decision therefore, or at those times, has been to decide to create an external entity rather than through other legislative means and introducing other legislative requirements on public bodies. And so I think in considering proposals for new office holders, whether that's commissioners or ombudsmen or whatever model might ever be proposed, there needs to be robust consideration of what the policy intent is of the legislation and whether that is best met with a further arm's length body or with direct obligations and legal requirements on public bodies. What I would say as well, though, is that a well-functioning, well-resourced and robust national human rights institution is part of a well-functioning democracy. That holding to account, that accountability function across duty bearers, which indeed includes the Parliament, as well as public bodies, is an essential strength of a well-functioning democracy. And the fact that we do use the mandate that we have at the moment to bring, as I said in my earlier answer, to bring forward, to highlight those areas of rights where that result in people being furthest away from access to justice, further away from living the life that this Parliament would intend for them as well. But in considering whatever next steps in future legislation and how to respond to those needs, we've also said in our written evidence that a cross-party deliberative approach to thinking about structures, functions, processes, and obviously this committee inquiry is part of that.
Thank you for those answers. So just so I am clear, and other members are clear, I think what you're telling me is that yes, you could incorporate those roles, but that would require your mandate to be looked at. So are you telling me that as it stands, you don't believe that the Scottish Human Rights Commission does properly represent the views of the disabled or older people?
I'm not saying that, no. We are in the service of all the people of Scotland. And the models that Jan has outlined, some of which could be attempted through a restructuring of the Commission, whether that's through a rapporteurship model or a thematic member of the Commission model, which is the case in other countries, and wouldn't require primary legislation, But the mandate extension that the Commission has been talking about now for some 10 years or more would require changes in primary legislation.
Can I add just very briefly? I think the reality of the Commission is it has 15 people in the Commission, and 15 staff, and probably 6 or 7 of those are the experts that do the human rights analysis, and then we have comms and engagement and business support and those sorts of things. So I think the challenge the Commission's always had, and I think the Commission's mandate and resource has arguably been part of the problem to date, and we've said that in our evidence in many places, with such a broad mandate to support everybody's human rights across all of those treaties on what has been till recently a fairly flat-line budget of about £1.2 million per annum and 15 staff. It's difficult to properly service all of those areas in the way that perhaps all of us would wish. And so this past year has been about refocusing the Commission's limited resource to do more domestic human rights monitoring and identify through our own evidence base where there are systemic failings for disabled people, for gypsy travellers this year, as we're going to be looking at next, across the communities of the Highlands and the Islands, and in places of detention. So it's a balance. We don't necessarily need mandate change for more resource, but if we want to have greater teeth, as it were, as a Commission, and to have greater numbers of members of the Commission, that would both of those things would require legislative change.
Okay, thank you. That's very helpful, because I think I now understand. So effectively what you're telling me is this is a capacity issue rather than an issue about powers.
I think it's both.
Okay, thank you. Yes, okay, thank you. So 2 more things I want to ask about. One is the Children and Young People's Commissioner, who we're going to hear from shortly. Now, you obviously, as an organisation, post-date the creation of that office. If it had been the other way round, would we need a separate Children's Commissioner if you had existed before that?
I think the question as phrased is really, well, how would the Parliament have been minded at the time? The Parliament was minded to introduce the Children's Commissioner, and then subsequently to create a national human rights institution with coverage across the international human rights treaties and standards. And so, I suppose, kind of retrofitting that, the way the question's asked is a bit difficult. I mean, to link.
Well, let me rephrase the question there. Is there any general reason, in policy terms, why the work you do as human rights, given your reach into all different areas, disabled, older people, couldn't also encompass children?
The Children's Commissioner was, as you say, set up before us. It was brought into existence to execute very specific functions around supporting the realisation of the rights of children and giving voice to children. And the Children's Commissioner has a very specific remit around advocacy and the paying special attention to groups of children and young people who have difficulty in making their views and experiences known. So that was a very specific intention of the Parliament at that time to create the Children's Commissioner. The recent incorporation process of the UN Convention on Rights of the Child Act has also been part of the wider incorporation process, but the enactment of the Scotland Act, the UNCRC Scotland Act. So during the process of that, the passage of that legislation, the merger of the commissions didn't happen. So clearly, ministers in Parliament were not minded to seek a merger and saw fit to maintain the current structures, while at the same time inserting additional powers to both commissions in the area of strategic litigation, and to encourage that partnership working between the two commissions.
Yeah, with respect, I understand all that, but the reason this committee has been established is precisely because there's an appetite to revisit these questions, which is why I'm asking you this question. So let me try again if I can. Is there any reason, in broad policy terms, while the work of the Scottish Human Rights Commission could not incorporate the work of the Children's Commissioner?
It would be my understanding that would require a further legislative change to our mandate.
But there's no particular reason why that couldn't happen.
If the Parliament were so minded.
Okay. All right, thank you. Well, there's one more question if I can, Convener, and that. The human rights, as we all know, are partly devolved and partly reserved. So we have the Equality and Human Rights Commission, that's a UK body, that's a Scotland office. And we have yourselves, the Scottish Human Rights Commission. Is there a particular reason why we have two separate organisations in the same space?
I'm smiling there because I'm old enough to remember the creation of both, and the comments at the time were, around, like buses, for a long time you want a Human Rights Commission, and then all of a sudden we have two. We have distinct mandates. We operate within distinct legal frameworks. The Equality and Human Rights Commission is the regulatory body for the GB Equality Act, and was the merger of three previous equality commissions. The Scottish Human Rights Commission was created as an office holder of the Scottish Parliament to give that strength, the purposes and functions that we've talked about of the Commission, direct function in Scotland. And so, as you will be well aware, the separation of powers are such that we have jurisdiction on human rights dimensions within reserved matters, and the Equality and Human Rights Commission does not. We have a very effective working relationship at the Scottish and GB level with the EHRC. We have a formal memorandum of understanding, which is part of our way of working across all office holders, and we're in the process of developing that MOU with the Children's Commissioner and elsewhere. And just as we have a very effective way of working, relationships with our sister national human rights institutions in Northern Ireland, Ireland, and the EHRC functions in Wales. And that's also a requirement of our international accreditation, that we demonstrate that we have those effective working relationships across sister organisations within the UK, because that then takes us into the various voting systems and deliberative processes of the Global Alliance of the National Human Rights Institutions.
Okay. All right. Thank you very much. Thank you, Commissioner.
Thank you. Thank you. Now turn to Lorna Slater.
Thank you very much. I'm going to do a little bit of context setting just to make sure I've kind of got my head around some of this. So, as a committee, we are looking at the broader landscape of all the SPCB-supported bodies. Now, no one has said that you'd end up with this landscape if you started with nothing. It's grown organically, so we're aware that there are overlaps and gaps, and that some of these bodies have been created as the result of scandals, failures in public services, or failures in the conduct of public servants, in terms of trying to fix a kind of urgent or immediate problem. And I think I recall, I think it was the Ombudsman, my colleagues can keep me right, who was saying that she was really frustrated that she was only allowed to react to complaints that she had and wasn't allowed to do that broader preventative piece. So, she may have had complaints from several hundred people about specific councils. She could only investigate those councils. She couldn't then broaden her investigation to all councils in Scotland, just because it might be a systemic issue, but she's not allowed to do that. So she was frustrated by that view, or by that limitation. But she deals with individual cases. If I understand correctly, yours is almost the mirror image of that. You deal with that broad systemic investigation and reporting, but without doing the advocacy and without doing the individual case support, because that's not your remit, that's not your job to do that. So I guess there's a couple of questions that I have around that, which is, with all these public bodies, there seems to be a sort of structure of the kind of preventative space, preventing harm from public services, proactively making sure that institutions are getting the right advice so that they handle your data correctly, so that the politicians behave themselves, that sort of proactive piece. And then there's a kind of reactive piece, which is okay, something's gone wrong. Some patients have been hurt, people who are in detention have had their rights unrespected. How do we then fix that problem? So some of these bodies, but some of the bodies do a mix of those things, some do one or the other, but yours does that specific preventative piece. If we are imagining, reimagining this landscape, because we have this proliferation of commissioners, would we reimagine it as one large body who had both that preventative and that reactive space, so that then within that larger body who was responsible for both that wider investigative systemic look and advocacy, you would have, is that what the reporters would do? Is that a kind of, can we imagine a structure that would encompass all those things to look after human rights in Scotland, rather than your rather narrow remit?
Well, in the imaginary, yes, yes, we can. What we see with different models around the world is sometimes rather than have the National Human Rights Institution takes the form of an ombudsman, which again are complaints-based. But some of them have within their remit the more of the mandate around the proactive promotion and awareness raising, or where their remits are limited to human rights-based complaints in relation to rights realisation. There are other structures that perform that promotion and awareness and directive function, and they can be at the local government level right through to national government. You know, the City Council of Reykjavik has a human rights office, that we had such similar functions. And so there are lots of different models that we could draw on. Where we are at the moment with our mandate and how we execute our mandate is we are both, you know, reactive and proactive. I mean, in our strategic plan, which we're required by our statute to produce, we have a 4-year framing of our work that's agreed with Parliament, and you know, the process binds us to that, and that's then operationalised through our annual plans. Our budget cycle is on an annual basis, so it's kind of rather at odds with that 4-year planning cycle. But that also means then that we need to be agile and responsive within our resourcing. But we also need to be, and are increasingly, agile and responsive to what's going on in Scotland. And that's where our participatory work, our consultative work, our horizon scanning, our treaty monitoring work tells us what are key issues. We're reactive, and so we then respond to. That's how we've formulated our spotlight research projects and so on. But we're also reactive to the parliamentary programme. So we respond to requests for advice, or we offer advice into the legislative process. And we are reactive to live issues. But as Jan says, with a staff team of 15 people, they're not all full-time. There's a limitation in terms of how reactive we can be to live issues, and we can't provide advice to individuals, so we can't be responsive in that way to individuals. We can't take cases in our own name, so we can't raise those issues through the court except through the new powers of strategic litigation within the UNCRC. And so, as Jan has said, it's about taking that systemic approach to rights violations and the proactive functions of promotion and awareness raising. I'll leave it there and let Jan come in if there's more to say on that.
If I can, just briefly, so I think, you know, to use the example of the frustrations of the Children's Commissioner, I think, sorry, of the Ombudsman, and the frustrations of this Commission. Yes, so the Ombudsman can take on individual cases, absolutely, but can't necessarily share the information about those individual cases with us as a Commission. Our mandate prevents us from providing advice to individuals. It's an explicit, you know, must not do, cannot do. And so, yes, we can look at things from a systemic research basis, but our outputs there don't have any standing, really. So it's, you know, we don't have legal powers of investigation. We can't compel evidence from public bodies when we are doing our research, and when we issue recommendations, they're not binding. So there's frustrations there, I think, at all levels, and whatever happens here, and I think this has been consistent across a lot of the evidence that you've heard, is a real consistent look at all of how that landscape knits together. So what's required ultimately to deliver access to justice for everyone are bodies perhaps not as many are on the table, but bodies who have the powers that are necessary, when necessary, to intervene and make a change. And I think there are frustrations, absolutely, in all of our respective mandates, and it would be really valuable to take a look at that. And certainly when considering whether to add new bodies into the mix or not, at the very, very least, to ensure that there is consistency in the powers that are being considered. Because one of the challenges that the current landscape has created is there are so many different powers available to so many different public bodies, and those that are being considered by Parliament just now have even different powers again. And I think, if I remember correctly, although that is now stalled, but the proposal for a Victims and Witnesses Commissioner had the broadest possible mandates that any public body could have, and certainly would have had more powers than the Scottish Human Rights Commission would have had for one particular group of rights holders. And we're now in the position, even through the positive work to incorporate the rights of the child into Scots law, but through the Commission we now have a bit of a hierarchy there around justiciability for human rights. We have greater opportunity and potential now to take action where we see, in partnership with the Children's Commissioner's Office, that there are rights at stake for children and young people, but those same opportunities for us as a commission to step in where we see rights at stake for their parents or for their neighbours or their cousins or their uncles, and we don't have those, and so there's an imbalance there that's actually not so much about how many bodies that we have, and it's more about the purpose and the functions and the powers of what we do have.
It's interesting to me because it seems to me, and you can see how this happens, where instead of redefining, for example, your remit to bring in that advocacy role to cover some of those gaps, politically, you can see why politicians go, I'll make a commissioner for X because it sounds great, I'm standing up for this particular, and it's a lot more glamorous, showy, headliney than I'm going to rewrite the standing orders or the legislation that covers the Human Rights Commission, because that doesn't sound as big a deal. But so we've ended up with this kind of pockmarked landscape of all these, all with the absolute best of intentions, but not bringing them together, not standardizing powers, and having this really different and overlapping. So that is really useful. I'd be interested in learning more, and maybe this is for the clerks, about the models in countries where the Ombudsman and human rights are have a different relationship, are combined, or because there clearly are in terms of both improving public services and making sure that people get access to justice, some overlap there that would be interesting to hear about. I'm interested to hear more about this proposal around the rapporteurs and what gap you feel they're filling.
The rapporteur model is a way of organising within a national human rights institution, where you can have, as they have done, I mean, there's variations on that. There's some international examples where the National Human Rights Institution has had designated commissioners within the members of the Commission for specific groups of rights holders. The rapporteur model, again, takes various forms. It can be a designated commissioner and or a designated team within the Commission. Now, with the Commission our size, we're kind of limited in being able to what's the word I'm looking for? Support that that way of working. I mean, we are increasingly working across functions in a more kind of project-based approach. But the rapporteurship model is about having those lines of specialism across the team, which we do, but they need to work across, our team work across all the treaties. And in relation to Mr. Fraser's question from earlier on, the other mechanisms like the independent, there is a range of independent mechanisms, including for the Convention on the Rights of Disabled People. So the rapporteur model takes different forms. It can be, so to summarise, either designated commissioners or within the Commission that there is this designated rapporteur function, which is a kind of crossover between sort of champion model, so a named function. We set all of this, or some of this, out in our 2023 report At a Crossroads, to try and give a flavour of the different models that there are, but we'd certainly be very happy to follow up directly with members of the committee or with the clerking team and the convener directly on what different models there are, and which would require legislative change and which are about reorganising some of the structure. Sorry, the question you had earlier on, I mean, about alignment and the frustrations that arise from the lack of alignment, I think are kind of at the core of this whole debate, really, aren't they? And I know from the evidence of the Ombudsman, that lack of own initiative powers, which in some ways perhaps speaks to, and I can't retrofit what was Parliament's intent in creating the different bodies at the time, but ensuring that separation between Parliament and what's the function of Parliament and what's the function of the external office holders. And I think we're very clear. We don't make laws. We don't create legislation. We advise on legislation, and we advise on where we think legislation is, or advise on when we think the intended outcomes in terms of rights realisation are not the reality in people's lives, and that's what we are currently empowered to do through our information and monitoring functions. But the frustrations, as Dan has said, do arise from the constraints within the mandate in terms of ensuring or securing the most effective remedies and recourse to rights realisations for all.
Okay. Thank you, Convener. That's me.
Thank you, and that segues nicely into Richard Leonard.
Yeah, good morning. And can I pick up on some of the issues that you've been discussing in those last series of questions? One of the standard questions that we're asking everybody is, because this is part of the terminology of this landscape, to what extent do you see yourselves as advocacy, and to what extent are you regulatory?
Good morning, Mr. Leonard. Thank you for your question. We're neither. We're not a regulator and we're not an advocacy body. We advocate for the realisation of rights in general, and we conduct our activities within our current mandate. So building that evidence base, as I've said, of rights realisation and denials, and disseminating that and encouraging duty bearers to meet their obligations, and for the Scottish Parliament to as the ultimate guarantor of human rights, to hold the Scottish Government and public bodies as duty bearers to account. So we don't regulate the domestic or international legislation. We monitor the extent to which rights are being realised or denied under the international conventions. And we monitor, as I say, the realisation of rights contained within those treaties, and take that analysis to the relevant treaty bodies through the complexities of that international process. 2 weeks ago, the Committee for the Covenant on International Covenant on Economic, Social and Cultural Rights heard evidence from across Scotland, civil society organisations across Scotland, and the NHRI, the National Human Rights Institution, alongside the UK delegation, where there's a very detailed scrutiny of the realisation of economic, social and cultural rights across the domains of the UK. So we take our evidence from Scotland to yourselves in the Parliament, excuse me, and internationally. So we neither regulate nor advocate beyond that general advocacy for the realisation of rights for all.
Thanks. That's very clear. That's very helpful. The other labels that have been bandied around, and we used it ourselves earlier on, is the extent to which you are proactive and reactive, and you answered that question that was posed to you by Lorna Slater. But it may be invidious, but could you put a kind of percentage on what's the balance of your workload between proactive activity and reactive activity?
Yeah, I can start on that. I think it's shifted, and it's shifted quite deliberately in the last 12 months through the new strategic plan to be more proactive, so to step into areas where the Commission does have concerns, albeit not through direct routes to the Commission from people and complaints, but through what we see, what's known to us, what's being considered by Parliament and other civil society organisations. And the Commission, is fair to say at the minute, under the leadership of the current Commission is really testing the boundaries of its mandate to be as proactive as it can. And to highlight and to invest its time and its limited resource in those areas where we are uncovering potential violations of human rights in certain sections of Scottish society. So we've outlined where we see it in places of detention. We have outlined where we see it in relation to the long-term detention of people with learning disabilities and autism. We are currently working with the Gypsy Traveller community on their experiences around cultural identity, and so on. It will go. So that's really testing the limitations of the Commission's mandate to do more proactive work and to step into that space. That's where the mandate does come up against its limitations, because what we can then do about it is then work with Parliament as the ultimate guarantors and ensure that it's on your radar and that you're moving things forward, and continue to advocate for a stronger set of tools for the Commission to enable stronger work. The reactive work, we also have shifted in the last 12 months away from being so reactive to the work of government and be more reactive to the needs of Parliament. So we are a creature of Parliament, is the phrase we use quite often, and deliberately so. So our role is to work with you as to support Parliament in your assessment of legislation as it is being passed, and not to provide as much support into government structures such as working groups and development of thinking around legislation. That's government's job. The role of the NHRI is to be independent and to provide Parliament with an assessment of what's been proposed, and to help keep you right in respect of those obligations. So there's more of a shift now to more proactive work, but even the reactive work from the Commission has shifted to be more in service of Parliament rather than government.
Okay, that's interesting. But again, I know it's probably invidious, but could you put a figure on it? Is it now 80-20, 50-50?
I'm going to say probably it's probably 70-30. So I think, in terms of proactive versus reactive. But actually, as an NHRI, and this comes down to resource rather than powers, it would be brilliant to do more and to support Parliament in every committee and every piece of legislation if we had the team to do that. So at the moment, the priority with the limited resource we have is to have moved more into that proactive space. But it would be lovely if it was 50-50. Yeah.
Okay, right. Thanks. That's helpful. And I should say, for the record, I think the first time Professor O'Hagan and I met was when she was working for the Equal Opportunities Commission and I was working for the GMB Trade Union. And I was struck by your written submission about your search for new powers. And some of those look like the powers that the Equal Opportunities Commission used to have in terms of litigation and supporting legal proceedings and so on. So, I mean, and for the record, it's worthwhile, I think, saying, Convener, that your long list of asks to strengthen your powers cover providing legal advice, being able to raise legal proceedings, to conduct inquiries in less limited circumstances, to require and compel information, to make unaccompanied and unannounced visits to any human rights duty bearer, and to hold public hearings and require duty bearers to be present. You also ask, I think, for a bigger commission, but that's just maybe a separate point. But could you run us through the difference that those additional powers would make to the work that you do at the moment?
Yes, you just reminded everybody of how long we've been in and around this space, Mr. Leonard. I think, to link the two questions, currently we have an obligation not to duplicate the actions and activities of other commissions. So at the moment we seek to add value, and that added value is by bringing a human rights lens and a human rights framework and analysis to questions, but of public interest and of rights realisation, and to bring that distinctive human rights framing. What these additional powers would allow us to do is to move much more, as Jan has said, and as your question is going to be much more proactive in securing rights for individuals, seeking access to justice and remedy and recourse. The limitations of redress and recourse to justice are what's behind those requests for the power to provide legal advice, to raise legal proceedings in our own name, is about bringing access to justice closer to people in Scotland. The incorporation of the international treaties would also go some significant way to obviously improving that justiciability and the domestication of international rights. Conducting investigations, we do have those powers at the moment, but they are both expansive and constraining, given the size of the staff team and the resourcing. To conduct an investigation the way it is framed in the legislation would be all-consuming for the Commission. And we don't have the powers to compel local public authorities to comply with the investigation. So there are limitations in each of the powers that we have. And so powers for a purpose is a well-used phrase in this space, and we're not looking for additional powers for the self-aggrandisement of the National Human Rights Institution, but for the National Human Rights Institution to be more effective in the exercise of its mandate and more effective in the service of the people of Scotland.
Yeah, I mean, it struck me, we had a debate in Parliament quite recently about the Highlands and Islands report that you produced, and there was a real sense of people's human rights are not being upheld in a whole range of areas, access to public services, access to health services and so on, to culture. But I can't really go to Inverness Sheriff Court and get a remedy, can I? I mean,
exactly.
If you had powers in that area, what more would you be able to do?
Well, what the Highlands and Islands Economic, Social, Cultural Rights Spotlight highlighted was that lack of remedy for people and the lack of implementation and framing and activating, operationalising a human rights framework by public bodies. The Scottish Government is currently consulting again on a mainstreaming strategy. We've been talking about mainstreaming for the whole life of this Parliament. Or rather the whole lifetime of devolution. But what we don't see is human rights being mainstreamed into the ways of thinking and doing of public authorities. And so the combination of incorporation through one route and having those rights immediately accessible to individuals in Scotland would make a significant difference to the realisation and to the ability of individuals and indeed groups such as those that we've identified in the Highlands and Islands, where access to healthcare, access to appropriate sexual and reproductive health being denied, the right to food, the right to clothing, or indeed education and housing.
To interrupt.
I'm just conscious of time.
Just conscious of time, and I appreciate those are all important points that were relevant to the inquiry and to the debate. Richard Leonard, is there anything further you wanted to ask?
Just one quick, much more straightforward question, a practical question, which is about shared services. One of the things that we are looking at is the extent to which there already exists the sharing of service support and the extent to which that could be enhanced. Where do you see the barriers to greater sharing of services lying? Maybe Jan Savage can answer.
Yep, yeah, I'll take that. So, the Commission totally believe in the value of shared services. We have a shared office accommodation with SPSO, and we also have a formal shared services agreement in place with SPSO, and they provide our payroll functioning, our finance transactions, our management accounts, HR support, and so on and so forth. The barriers moving forward, I guess, are in relation to the infrastructure that's available. So it's been brilliant that SPSO have been able to provide that for us, and they're of a size and scale that's been an option. But I think moving forward, if that is something that other office holders were to be interested in progressing with, there needs to be a discussion about where and how that should sit. I think some barriers may be around institutional independence and the interaction between the jurisdictions of certain office holders. So the Information Commissioner has jurisdiction over all of us in respect of FOI, for example. So would it be necessarily appropriate for us to share data platforms? I don't know. So there will be some elements of that to be considered. But as a principle, it's a good principle, it's a best value principle, but it requires the right sort of infrastructure to be available. And perhaps that should be the next step, is actually taking that strategic look at it. What are the services that can be shared, should be shared? How do you scale them? How do you plan for that? That would be probably the biggest barrier at present, because I don't think that exercise has been done.
That's great. Thank you very much. That's a very helpful answer.
Thank you. I'm going to bring in Ash Regan. If we've got time, I'll come back to you, Lawrence, later. Ash Regan.
Thank you, Convener. Good morning. The committee are very interested in the ideas around accountability and scrutiny and whether you think that that is robust. Obviously, your organisation was set up by Parliament to uphold human rights and to make sure that policy meets human rights requirements. You'll have seen that last week the EHRC intervened in the wake of the Sandy Peggy NHS Fife case. But I note we've not heard from you on that case. We haven't heard from you on single-sex spaces. We haven't heard from you on toilets in schools. We haven't heard from you on intimate searches policy of the British Transport Police, Police Scotland's policies on sex and gender. We haven't heard from you across a range of those things at all. I would argue that women's human rights are very much affected by those issues. And so my question to you would be, how then are you accountable to Parliament and also to the people of Scotland if you are failing to uphold the standards that provide the very reason for your existence?
Just before we proceed, if witnesses and colleagues can just be careful of sub judice, answer that as you wish, and then we'll move on to. I'm not challenging.
Case. It's about the wider issues.
And I'm not challenging that the importance of your questions, Ash Regan, or the way you've asked them. I just, for context, wanted to make those points. So thank you, Ash Regan, and sure. over to you, Professor O'Hagan.
Yeah, I mean, as you say, I mean, I won't comment specifically on the Employment Tribunal that's live just now. I will comment on the wider set of issues that Ms Regan has raised. We are not the regulator of the Equality Act, and that was the basis of the EHRC re-clarification of its own guidance on single-sex spaces and the protection of single-sex spaces. That is the law, and as I am on record at committee elsewhere recently, of course, we uphold and seek to protect the law as is, and that's the way in which we function. We share a concern as a Commission to ensure the effective protection of rights in law for dignity and respect for everyone.
If you can forgive me just for a moment, I've set out where there's a number of issues. You know, there's many people across Scotland who genuinely feel that women's human rights are under attack right now across a number of those issues, and more than the ones I've set out here. And yet, this is a genuine question. I feel I'm not hearing from the Commission on these issues, either side, one way or another. We're not hearing from you, not making those interventions. Would you agree? Would you agree with me on that?
We're not making those interventions when they are a matter of the Equality Act, because we're not the regulator of the Equality Act, and that's not within our remit. That's within the remit of the Equality and Human Rights Commission.
But obviously CEDAW is within your remit.
CEDAW is indeed within our remit.
The Istanbul Convention is within your remit.
Yeah. And as I was going on to say, there are a number of human rights treaties and instruments which the UK has ratified, and which we discuss regularly at Commission. And as a pluralist Commission, we have a range of views which are raised and discussed within Commission. And we work through the range of relevant human rights instruments which provide instruction on the protection of rights for all, and take a range of existing legal frameworks into account. As the previous conversation about reactive and proactive pointed to, we've not been directly engaged by rights holders or public bodies in these questions, and therefore have not, beyond providing advice to the legislative process, which predates my time as chair. We haven't been engaged in these processes recently. Where we do ensure that the rights of women are surfaced and foregrounded is across our treaty monitoring, across the treaties, and we've been engaged in the treaty reporting cycle recently, and we will shortly be, within the next 12 months, the CEDAW process will be kicking in, and so we will be reporting on the status of rights of women in Scotland. through the CEDAW process.
In terms of upholding women's rights across Scotland, then, would you say that you agree with John Swinney that trans women are women for the points of policy that I've been discussing here, or with Reem Al Salem that sex means sex when it comes to single-sex spaces?
I'm conscious that we're straying into the remit of the Equalities Committee. I will allow you to answer that as you wish, and then I would be grateful if we can move on to the questions relating to this committee. Perhaps also, Professor Hagan, if you wish, you could give an undertaking to engage in written correspondence with Ash Regan and with the Equalities Committee as is helpful or appropriate.
I think that's a very helpful intervention there, Convener. We're very happy to pick up these issues in writing with this committee, with Ms Regan individually and indeed with the Equalities Committee. The question Ms Regan has asked is also before the Supreme Court at the moment in terms of definitions of women, and the Commission is very alert to waiting for that decision and the implications that may have for law and policy and duty bearers and the realisation of rights for women in Scotland. So we are very engaged in this matter. We have, in my tenure over the last 6 months at the Commission, engaged in regular discussion on this. We have an alert watching brief, as I say, on the Supreme Court and alert to the extent to which case law is instructive in how international human rights standards are interpreted, and we can continue. We can provide further detail on that to this committee, to Ms Regan and anybody else who wishes. Our commission minutes are in the public domain, and that includes a series of special commission meetings in relation to the progression of the Supreme Court case, and we operate under a process of collective responsibility, as you would expect, through our governance structures, which was the initial point of Ms Regan's question, which was about accountability and scrutiny. As we've set out in our written submission, we have multiple layers of governance and accountability measures internally, as well as to Parliament, as well as to the international frameworks that I've mentioned earlier on, and ultimately to the people of Scotland.
Thank you. Is there any further questions on the remit of this committee that you want to ask?
So you've set out there that there's different mechanisms of scrutiny, that you feel that they're working together and that you are accountable. Can you suggest any ways that you think that accountability could be improved, or there's other areas that you think could be made more robust?
I think any organisation can always improve. The Scottish Human Rights Commission is absolutely a learning organisation. I have come into a very dynamic commission, which is working through the recommendations from from a recent governance review, which was discussed and supported by the Scottish Parliament corporate body, who've approved and supported the recommendations and indeed supported the Commission in the current change and culture change programme and structural change programme in which we're engaged. Commissioners have been part of that process from the outset. It was a Commissioner-led process to review the Code of Governance and introduce a Code of Governance for the first time, which is very clear on collective responsibility and the obligations of conduct and engagement of commissioners as well as staff, and our accountability to our mandate, our accountability to Parliament and accountability to rights holders. As I say, we're a learning organisation, and so we take very seriously how we can improve. We use our relationships with the European Network of National Human Rights Institutions and the Global Alliance of National Human Rights Institutions, looking for best practice elsewhere, incorporating that practice as appropriate. Our Code of Governance was formulated through a wide-ranging exercise drawing on the Nolan Principles, but across equivalent organisations in the UK and elsewhere, to have as robust a Code of Governance as possible. But that is constantly under review as well as our appraisal system. I'm appraised by the independent assessor, and we have a series of accountability measures into Parliament on a regular basis.
Oh, sorry.
So just add in respect of parliamentary accountability mechanisms and how that operates at the moment. We have the standard annual report required by our statute that we have to deliver to the Equality, Human Rights and Civil Justice Committee, which we do. I think we've outlined in our evidence, though, that we feel that there could be better interaction, perhaps, between a number of the parliamentary structures. So the Equality, Human Rights, Civil Justice Committee absolutely hold us to account in terms of our delivery against a strategic plan on outcomes, but there's not necessarily that crossover around the finance and the budget scrutiny, and therefore the Finance, Public Affairs and Administration Committee, the Equality, Human Rights and Civil Justice Committee, and indeed the SPCB as a committee, perhaps could have a better interaction when it comes to looking at issues of mandate. And increasingly, as the Commission has moved into more of that proactive accountability space, that will become increasingly relevant when we look at how to then service even its existing powers. So Angela mentioned earlier, for example, we do have powers of inquiry. We don't have budget to deliver on those powers of inquiry. We need to make the case to use those powers of inquiry. So in terms of accountability structures and ensuring that we're making the business case appropriately, that we're delivering appropriately and that we're accounting for that appropriately, there's perhaps an example there whereby those three committees could come together a bit more usefully.
Okay, thank you, convener.
Thank you, Ash Regan. Lorna Slater, very briefly, you had a last question, and then I'll also just ask a last question and just some succinct answers because I'm conscious of time, if that's okay, please.
Thank you so much, Convener. Just picking up on something you said when Richard Leonard was asking you, which is about you can't duplicate the functions of other commissioners. Does that mean as more commissioners get created, your powers will be diminished? Because especially with the justice and the victims one, if they're so broad, does that mean you have nothing left to do? Do you mean like is it? No, does it? Are they so because they're now encroaching into your space? Does that reduce your remit?
Our remit would remain in relation to the international human rights standards, as well as the realisation through domestic legislation, human rights legislation, but Jan's probably more across the detail than I am.
So no, I mean it wouldn't diminish the mandate of the Commission. However, it would be fair to say if the Commission had a concern, take the example of the recent work we've done in deinstitutionalisation and independent living. If there was to be a disability commissioner in existence that had stronger powers of investigation, etc., then that would have been a piece of work that the Commission couldn't have done. And then that's a challenge for us as a human rights institution. If we have evidence of problems and concerns, if there was then to be an overlap of mandate with another organisation that did have a statutory duty to investigate that, we would not have any opportunity to influence what that body does, and therefore our ability to move in that kind of space would be diminished. So it wouldn't necessarily diminish the power of the Commission, but it would certainly it would be an additional consideration that might not enable us to be as agile where we see concerns emerging.
That was it, Convener.
Thank you. That was a useful question. I just had one last question. You talked about identifying what to investigate, and I just wondered briefly what the process is of that. Do you do it on the basis of statistical analysis of what is coming in through the door, to use a colloquial expression, or particular areas of interest? I just think that's quite relevant to the wider considerations for us.
Sure. As you would expect, there's a range of ways in which we formulate that. Our decision-making process in terms of our priority setting process and then the decision-making process is published on our website, again in full transparency of the work of the Commission. But we use a range of data sources, so our own evidence base as generated through our treaty monitoring work, our monitoring of correspondence into the Commission, the wider availability of a whole range of secondary data, from, again, a whole range of sources, whether that's qualitative or quantitative data. If I can very quickly say, for example, our strategic plan contains a commitment to focus a spotlight around poverty. So from a human rights perspective, how do we add value? So poverty is endemic and systemic in Scotland. There are many organisations engaged in poverty alleviation and campaigning around poverty. But what would our approach be? So in consultation with members of the Commission, members of the staff team, and through a range of participatory processes, we're working through what would the most effective approach to surfacing poverty in a human rights framing, and how would that add value. So in that process, we would draw on a range of sources of evidence, including increasingly through our participatory approach, and our participation strategy will be published for public consumption and enjoyment next month.
Thanks.
Can I add to that?
Yes,
Just to reassure, so whilst our mandate prevents us from providing advice to individuals, as a public body, individuals do get in touch with the Commission, and we are open to that, and we do receive letters and correspondence. And a letter recently from Mr Leonard's office in respect of human rights in place of detention. We receive letters from prisoners, etc. Whilst we cannot take on the case and we signpost, we do listen, and we notice, and we record the trends and the themes, and that provides useful evidence to the Commission as well around where there may be violations of human rights that no one else has seen yet, and that's a really, really fundamentally important part of the role of the NHRI. That's why our spotlight projects are called spotlights, you know, shining a light into the areas where people are furthest away from access to justice. So just wanted to explore that whilst we can't provide advice, we're not, you know, the doors aren't closed. We do hear from people, we do speak to people, and proactively now we do more of that through our participation strategy. And even where we can't take on cases, we do monitor what those issues are. And that has in no small way informed part of next year's priority areas, where we're looking at perhaps orders of lifelong restriction, for example. That wasn't an issue that we considered as part of that spotlight, but as a result of the publicity around that spotlight, people who are concerned by that matter have contacted the Commission. So that has raised awareness at Commission level of that particular policy matter.
And that's demonstrated in your recent working, for example, with regard to Cables Wind House in Leith, in my constituency, which was recently, of course, reported. Okay, is there anything you wanted to say today that you haven't had a chance to say that you just want to leave us with finally, or have you managed to cover everything that you wanted?
I think very briefly, and it relates back to Richard's questions about shared services, and I think it's about the role of the Scottish Parliament corporate body, and how well resourced it is, what strength it has to provide some of the shared services, some of the organisational support to the office holders. We've seen the Scottish Parliament corporate body office holder liaison function reduced from 3 staff members to 1 over the last 10 years. I think in terms of some of the procedural and process gaps, there could usefully be some further conversations coming out of this committee and with office holders and SPCB and the corporate function of the Parliament around how best the Parliament can support the organisations it has created through the functions of the SPCB.
Okay, thank you. Just so to just clarify a few things for completeness about the position with the Victims and Witnesses Commissioner, just for clarity, that's still in consideration in terms of stage 2 of the Victim Witnesses and Justice Reform Scotland Bill. During the course of today, some undertakings were given with regard to Ash Regan and her specific points, and with regard to the committee and our work in response to Lorna Slater. So grateful in advance for that written correspondence to the committee. And just lastly, to thank you both very much for your written submissions, for your evidence today, and for your time. And I'll now suspend briefly to allow for a change of panel. Thank you. Welcome back, and I'm really pleased and grateful now to have Colleen, Children and Young People's Commissioner for Scotland, Gina Wilson, Head of Strategy, and Nick Hobbs, Head of Advice and Investigations. Thank you very much for being with us today and for your written correspondence in advance. And I'll just move similarly to questions as I have done for all the commissioners, and just be grateful if you could set out what you consider to be the purpose of the Children and Young People's Commissioner, and how does this differ from the role of ministers, MSPs and other bodies? As I said before, we all have an experience and understanding of that, but it'd be really helpful for us to hear your position initially.
Thank you and good morning. So the Office of the Children and Young People's Commissioner was established by Parliament to promote and protect the rights of all children and young people in Scotland. The specific functions are set out in the legislation and your papers, but fundamentally my role is about holding government to account on their human rights obligations to children and young people. Now that's obviously distinct from ministers because they are the key duty bearers, but my role is and was always intended to be complementary to that of MSPs. You have powers that I don't, principally to legislate, and this office has been given specific powers and functions that MSPs don't have. So, for example, most recently with the power to take litigation. Parliament created this office because it recognised that children and young people cannot vote. They do not have voting power. They do not have economic power. They are consistently having to make their way through a world that is created by adults making decision-making processes and structures designed for and primarily for adults. So you created this to enhance decision-making in the best interests of children and young people. The Parliament required a commissioner just for children, focused exclusively on children's rights issues. I do this supported by a specialist multidisciplinary team, and you've given me a range of tools to help me do this. So I monitor and review the law, policy and practice in terms of how children experience their rights with children and young people. I carry out investigations, and most importantly, I must pay special attention to children and young people who are furthest away from being able to express their views and enjoy their rights. Crucially, for my office, my priorities are driven by children and young people themselves.
Thank you very much, and that was really helpful and well put. And in that space, how do you perceive the current role of the SPCB supported bodies in enhancing public trust and confidence in public life in Scotland? And of course, with yourselves, that's helping children and young people in Scotland to feel trust and confidence.
Absolutely. So the creation of this office was an absolute clear message from Scottish Parliament to children and young people that their rights matter as much as adults' rights. This is a symbol to children and young people of the public trust that Scottish Parliament wants to install in them. But also it's not just a symbol, it comes with powers and it comes with the ability to hold those accountable to account for that. For children and young people who are furthest away from enjoying their rights, they can feel extremely marginalised, alienated, and sadly we have many children and young people who have already experienced multiple rights breaches. This is such an essential role and resource to help those children and young people to ensure that those experiences are documented, to ensure that those experiences are used to hold those responsible to account, and most importantly, that Scotland learns from those mistakes and can drive forward positive change. In my time as Commissioner so far, I've already met many children and young people, sadly, who have shared with me harrowing accounts and stories of rights breaches. And they share those with me so that I can document those and I can share them with you so we can together hold people to account for that. But one of the best parts of my role is also when I go out and I tell children and young people that this role is independent from government, that Parliament has given this office those powers for children and young people. And I see children lift their heads up and they realise the importance that's been placed on their rights and that Parliament has given this office those powers for them.
Thank you very much. I'm now going to move to Murdo Fraser.
Thank you, Convener. Good morning. I think you were here for the previous session, so I'm really going to ask you exactly the same questions I asked the Human Rights Commission. And just to contextualise that, our remit as a committee is to look at gaps and overlaps between existing commissioners and also the case and the criteria for establishing new ones. So let me start by asking this question. There are a number of proposals in the pipeline for new commissioners you'll be familiar with. For example, a new commissioner for the disabled, a new commissioner for older people. Given you're the commissioner for young people, do you think you could make any argument against there being another commissioner, say, for older people or the disabled?
As the Children and Young People's Commissioner, I think what's really fundamental, and I expressed in the response to my opening, is that children and young people can't vote. So this is absolutely fundamental to why this commission has been established. It recognises that there is an inherent power dynamic that children live within. Okay, they don't have power. They aren't able to reach out and make their voices heard and known in the ways that other constituency members can. So I think that you've heard some kind of compelling arguments earlier around about ways in which other bodies could be enhanced or supported to strengthen, adults' opportunities to have greater accountability for rights breaches. But from a children and young people's perspective, there is a very specific reason why they have been given by Parliament their own office holder.
Okay, well, thank you. That's a very clear answer, so thank you for that. So looking at the criteria that currently exist for establishing new commissioners, do you have any views on those criteria and whether they have been properly followed in the past or whether they need to be adjusted?
So we put in our written submission that we do think that the criteria generally is quite strong. But I think that it's really important that it is adhered to in terms of assessed against any proposals for new commissioners. And we did add some thoughts from us in terms of additional, considerations. Whether that needs to be an independent office holder. Independence is absolutely fundamental in my experience of the ability to be able to do the role. Considering whether there is opportunity within existing office holders' remits and whether there are opportunities to strengthen, remits or functions and powers within existing office holders. And we noted in our previous written submission and this one as well that really careful attention to the legislation that underpins it. So it's really important that there can actually be helpful overlap within office holders. So the ability to collaborate and to combine strength can be useful, but it's really important that when the legislation is written that there isn't anything that would be a duplication or inhibit the possibility of office holders working together.
Okay, thank you. In relation to the relationship between your office and the Scottish Human Rights Commission, now we know that your office existed first and the Human Rights Commission came later. If we already had a Human Rights Commission, would we still need a Children's Commission?
Yes, absolutely. So the Scottish Human Rights Commission is an adult-focused organisation. The Children and Young People's Commissioner is a child-focused organisation and has been created to put children's priorities first. Everything about my office, we share international human rights expertise, but if you look at my team, children live their lives in a community, but they experience that community differently as a child and young person. They have different services, they have different experiences, and therefore within my team, although we hold international human rights expertise, we hold expertise about children's services. So you absolutely, ultimately it's for Parliament to decide this, but in my view, children and young people need a space. This is their space that has been held for them, protected by them, that recognises the inherent imbalance of power in society, and therefore they shouldn't have to come to one national organisation and again navigate their way through that organisation to find their space. My office has been created with a unique identity to make it child friendly. It has an office that's child friendly. We go out, every single member of my team has to be able to participate and deliver work with children and young people. So everything about this office holder has been designed, created and consistently improved to ensure that we can reach the maximum number of children and young people.
Okay, thank you. Thank you for your answers.
Thank you, Murdo Fraser. Sorry, Gina Wilson, do you want to add something to that briefly?
And Mr Fraser, you asked our colleagues in the SHRC this question in terms of are there any policy reasons why the Children's Commissioner couldn't be merged with the SHRC. So I'd like to give you some answers to that, please, if it's possible. Let's be clear, that would be regressive in terms of children's rights. We've just passed the UNCRC Incorporation Act. I can't imagine a CRIA saying that that would progressive realisation of children's rights to take away a body which has children mainstreamed throughout the entirety and simply having part of that in an adult-focused organisation. It would create a significant disadvantage for Scotland within its UK position. It would be the only nation that didn't have a dedicated body for children and young people, and you would have to justify that as Scotland to the international community about why you had taken that step. There's no evidence base. The stakeholders, who are children and young people in our case, are not calling for that level of change. So what would be the evidence for that move? And I think it's important to say, you've heard at SHRC how much they are struggling at the moment to cover their mandate with the resource in which they have. Can you imagine what would happen if you simply added children to that picture? And if I could give a very specific example, if SHRC had come first and the Children's Commissioner was simply part of it, you would not have a UNCRC Incorporation Act, because incorporation of all human rights treaties would have been the priority. And we've seen where the Human Rights Bill currently is. So I think there's some very real policy reasons.
Thank you. In defence of my colleague Murdo Fraser, when we ask these questions, we are not saying it from a position of a proposal or a set view. We are asking these questions to cover the remit of our committee and to make sure we obtain the evidence that we need to take this forward. And in that context, Gina Wilson, your examples there are very helpful for us. So between Murdo Fraser's questions and the response we've received today, that's been really helpful. So thank you for adding that. Commissioner, yes, you wanted to add?
I just thought it would be helpful to add that on a day-to-day basis, we have excellent relationships with the Scottish Human Rights Commission. So whilst we, rightly are here to absolutely explain to you why this is essential to retain in its fullest form for children and young people, it's really important for you also to know that we can come together. We do come together and we create work when we can see that that will be beneficial. And I've got two really specific examples of that. So last year we co-commissioned some research that was about actually looking at where can children, young people and adults access human rights advice across Scotland. And most recently we have been writing a joint letter around about the use of restraint and the continued need for a legal framework for that across Scotland. So I thought those two examples would also show how we usefully can have overlap and come together to use our combined forces.
Thank you both. Very, very helpful insights, examples and responses. Thank you. Lorna Slater.
Thank you very much. I'm interested in, so we've just been hearing from the Human Rights Commissioner, who described their role, or at least I was sort of describing it to them, and I think they signed up to what I was saying there, as almost a mirror image of what the Ombudsman does, in terms of they are looking at systemic, almost preventative level advice, where they investigate and research a system or a group, and they go and do that work and create a report and give advice on that, whereas the Ombudsman would react to individual cases, can react to complaints coming in. In terms of the work that you do you do that preventative research and advice for broad groups, I don't know, maybe children in care, I don't know what groups you might have been looking at, as well as the reactive stuff? Do you take on specific cases or investigation of any particular breaches?
Yeah, so we are both proactive and reactive in the nature of our work. We have a strategic plan, which, as I mentioned earlier, is set by the priorities of children and young people. And we undertook a really extensive work looking at consultation, research for children and young people, gathering data from them and setting priorities that are driven by children and young people. But we also are responsive to what's happening as well. And in terms of the cases, for example, that's actually we've got our new strategic litigation powers, and I think I'm going to move over to Nick actually to come in on this, because I think this gives you a really great demonstration of how we work both proactively and reactively.
I can talk about both investigations and litigation, if that's helpful.
Please.
The investigation power that the office has had for some years, these are really significant and substantial pieces of work. They can last anywhere between sort of 6 months to 12 months, depending on what the issue is that we're looking at. They're driven by the priorities of the Office's strategic plan, which is itself informed by children and young people, but also by our assessment and analysis of what the most pressing human rights issues are for children, drawing on the concluding observations from the CRC, drawing on intelligence that were provided by other bodies, by children and young people themselves, by parents and advocates and lawyers. So if you look at some of the topics that we've investigated in the past, restraints, being the Office's very first investigation, a really substantial piece of work that continues to have ongoing impacts on the debate and discussion around policy and legislation within the Scottish Parliament. Our most recent investigation into police use of force, which is running at the moment, which is a really important way of ensuring that Police Scotland is held accountable to its human rights duties, that we're making sure that that they are behaving and acting in a way that is human rights compliant. So these are really important powers. The litigation power, which came along with the 2024 Act, is probably the most substantive and most significant change to the Office's role and remit since it was created back in 2003. We made the decision at the time that we weren't going to seek additional funding for that through the bill process. We were going to reprioritise our internal resource, and we did that because it wasn't clear at that point what the scale and scope of the litigation that we were going to be engaged with was. That is now becoming much clearer. And we are working very carefully to make sure that we get the absolute most out of the resource that we have available to us. So we're about to complete an internal audit on the way in which we resource those litigation powers. We're putting one of our legal officers through the solicitor advocate course, so that will allow us to save money on instructing counsel. So we've taken the view that we will get the most bang for our buck out of the existing resource. Should we then, at some future point, have to come to the Parliament and ask for more money, that will be on the basis of a really sound and robust case, rather than on a kind of speculative business case.
And do you take on cases like the Ombudsman does, where you can give individual redress to something that's gone wrong?
So our power is systemic and strategic. So the litigation power would be related to individual cases. So we're intervening in a case that an individual child or perhaps a group of children and young people have brought. But our focus is not to represent those children. Our focus is to drive a systemic or strategic change within law.
So there isn't a specific overlap with the Ombudsman there necessarily, although presumably they can do similar things for a group of people of any age.
We have an individual investigation power, but that is constrained by law. So we're obliged not to use that in a way that duplicates the function of another organisation. And SPSO is the really obvious example of. If something falls within SPSO's remit, then we would, as a matter of law, not be able to investigate it.
Not be able to do that. Okay, no, that's really interesting. In terms of resourcing and what you've just said about your powers, it seems to me that you have more, within the kind of group of children, a group of humans that are children that are your responsibility. You have more powers than the HSRC, SHRC, I'll get there in the end, has, because they only have this sort of limited researching powers. You have a lot more powers there. So I suppose, one of the sort of concerns I was hearing in your tone, Gina, to Murdo's questions, was this idea that you would get sort of sucked into them because they have much less powers than you do. But there is something around envisioning what you do, but for everybody, if you like, because we do have this perceived gap or real gap where we don't have these powers for disabled people, older people. To some extent, could we imagine it where you guys are actually the exemplar? You do this for children, but actually everybody deserves this. So is there any reason why, with dedicated resource, expertise, and the right, responsibility for leadership this couldn't be duplicated in terms of one of our other witnesses talked about a sort of hub and spoke model where you have a common resource in terms of HR and offices and so on, but you then have responsibility for children, under some sort of broader human rights. I'm imagining an imaginary complete restructure, broader human rights where you've got children, but we give the same excellent service that you give to other underrepresented groups of people. Is there any particular reason why that wouldn't work, or we copied your remit elsewhere?
So In terms of our powers and functions, I think we have good level of powers, good, that are appropriate for us to deliver our function. And what we actually saw in some of the new proposals that came from commissioners is that they had been modelled on the fact that this office has been delivering extremely well and has given those appropriate. So what we, and hopefully is really clear in our opening response, is that the Children's Commissioner shouldn't be part of another organisation. It should be a distinct organisation for children. But we do support where SHRC are saying actually our powers don't reach, can't enable us to deliver on the mandate that they have been given. So I hope that's clear in response to the question that, yeah, I'm supportive of some of, those asks where, particularly SHRC are saying if there is an opportunity through this committee to visit that. But what we don't want to see is that being taken forward in a way that inhibits at all my ability to be independent for children, to deliver for children, to set my priorities for children. But I absolutely recognise what you're saying actually about the fact that as an organisation we feel as though that the mandate we've been given is supported by the legislation that gives us those powers to enact our functions. So
independent of whom? So I don't think there's any disagreement that you need to be independent of government, independent of Parliament. Who else do you need to be independent from?
Well, I think that at the moment, as a commissioner, I take my direction from children and young people. I would not want to be in another organisation where I was then, the priorities were being set against priorities perhaps of adults as well. So if I give you a really concrete example, Scottish Human Rights Commission and the Children and Young People's Commission have two different strategic plans. Those have different priorities. They should have different priorities because they're being set by two different groups of stakeholders. So the independent human rights model and the independent children's rights model needs to be independent of government, and it has to be the ability to work and set that direction. But for me particularly, it's about being led by the priorities of children and young people.
Okay, so I think that's really clear in terms of what you need is that ability to set those priorities. I'm not clear that that's dependent on any particular organisational structure, but I think that's a really clear requirement to be led by the needs of children and young people. That's me.
Thank you very much. On a slate, I now move to Richard Leonard.
Thanks very much and good morning. Can I just pick up the points about powers here, and you might be able to help me a little bit, because as I understand it, you've got investigatory powers into the human rights of groups of children. You've now also got investigatory powers into the human rights of individual cases. You said that though the kind of prosecution of individual cases rests with the SPSO, but when the SPSO came to see us, they explained that they had no enforcement powers. So they can make recommendations to public bodies, even to Parliament and governments, but there's no binding requirement on their recommendations to be followed. Is that the model that you want?
Well, we don't have enforcement powers within our investigation function either, unfortunately. I mean, if you're offering them, I'll take them. quite honestly.
Imagine it, Mr. Hobbs. Would you like them?
Yeah,
that's the collective view of the Commissioner and the office.
We have a power to require organisations to respond to the recommendations. So we can. In terms of an investigation report, we can require a response, but that's obviously not the same as an enforcement power. There is potentially, in some cases, a route through to the litigation power then. So it might be the case, depending on what the subject is, that we're able to move from an investigation into legal proceedings under the UNCRC Act. So that has been a really important and valuable addition to the office's power and structure.
Okay, thanks. That's helpful. One of the things that we're asking every witness that appears before us is this distinction that's drawn between whether you're a regulator or an advocate. People say to me, the Children and Young Persons Commissioner, that's an advocacy commission. How do you define yourself?
So we define ourselves as an independent children's rights institution. So we don't recognise the term advocacy commissioner. And actually, although I'm a champion for children and young people's human rights, our role and our remit and our powers that have been allocated to us as an organisation go well beyond that. And it is about that dual role, actually, of promoting, but also protecting and holding to account.
Yeah.
And if I could just come back in on the powers point, where we are seeking additional powers, and it goes to exactly this question, is that the power to require a response from government or from another public body is very specific to the investigation power. What we are seeking is a broader power within, for example, an annual report to make recommendations in a report that's laid in Parliament and be able to require government particularly, but also Parliament potentially, to respond to those recommendations.
Okay, but and just going back to the regulator and advocacy distinction, do you see yourself as having any regulatory role?
So we do look at regulators, you know, and actually say, and we will promote to them and look at how are they actually enabling the delivery of a children's rights approach to the work that they do. So, for example, we have ongoing discussions at the moment with HMIE. You know, so there's a huge amount of work happening around about education reform. And I have set up, you know, regular meetings to say, actually, I can see that you are about to really look at what is the framework for assessing, you know, educational impact in schools. What's the model? How are children and young people involved in that? So we have a relationship with regulators that oversee, you know, children and young people's role, but we don't have a specific regulatory remit.
Okay, right. That distinction's well made. I think the other question I wanted to put to you was, again, one I put earlier on to the Human Rights Commission, which is about the shared services and whether, from your perspective, there are some obvious barriers that are preventing a greater sharing of services between the various SPCB supported bodies.
Mm-hmm. So hopefully committee is aware that we're involved in shared services as well. So we are co-located in Bridgeside House with multiple other office holders, and we also benefit from facilities management through that, health and safety support as well. And my own head of corporate services also led on some shared services around about procurement of payroll services as well for multiple office holders. In terms of barriers, I think looking forwards, I'm very open, you know, as an office holder to the possibility and to continue as office holders as a group. We've been meeting regularly to discuss this, and my head of corporate services is a member of the shared services network, you know, of peers who look at that on an ongoing basis. I think barriers are potentially, as you heard earlier, just being really clear about where should the management and leadership model sit for that. So at the moment, there are almost 3 or 4 different ways that's being delivered through the Scottish Parliament corporate body, who hold some shared services through SPSO, and then individual office holders are proactively trying to take forward opportunities as well. So I think some clarity around about if there was a progression, does that organic model work? And does that continue? Is there a need actually for clarity of where that should sit longer term for office holders? And then I think capacity for all of us. So there's always more work to be done to deliver on our, you know, core purpose and our mandate. So I think really clarity about the leadership and management, where it should sit. Some feasibility work as well to really understand the principles in which any additional shared services should be taken forward, and capacity to prioritise that, you know, over when you're meeting with children and young people and you're hearing these really serious rights breaches and you want to progress that work. So just balancing all of that and have an appropriate resource to take that forward.
Okay, thank you very much. Thanks.
Thank you very much. And just in that area that Richard Leonard's asked about, I'm conscious that your powers were extended in 2014. Mr Hobbs, you've given some indication of other powers that you think may be useful, but in a similar way that the Scottish Human Rights Commission did in their written submission, if following today you wanted to give a formal position or further consideration around which other powers may be appropriate, useful, helpful in the public interest, then please do feel free to follow up with the committee on that in writing. Okay, thank you. Ash Regan, I'm now going to move to you.
So the committee has a strong interest in accountability and scrutiny and how effectively that's working. So can you say a little bit from your view in terms of how you feel that that is working? Do you think it's effective? Do you think that you are being held to account in a robust manner?
Thank you. So in terms of accountability, there's multiple layers. So we have audit, external and internal audit. We have our key parliamentary committee that since I've been in post, I have an annual scrutiny session. SPCB has sessions with us, so I have an annual session with SPCB leadership, but also have ongoing, and I have an annual evaluation of my work as well. I also have a young advisors group, and we meet with them monthly, and they represent young people from all across Scotland, and I update them on work that's progressing, or my team updates them, and they can challenge and ask questions and probe as well. And we also have very strong relationships with children's sector, civil society, and a very open relationship with them, actually. So there's the formal mechanisms for me for accountability and scrutiny, and there are also those less formal but very important mechanisms for holding us to account as well. My experience of this so far has been very positive, actually. I found it meaningful, I found it helpful, I found it probing, but also kind of validating as well in lots of ways. But also we do identify that I think it is challenging, you know, for MSPs and for committees and for the general public to be really have that level of clarity actually about, we've mentioned before, we're dynamic, so we have a strategic plan and we're delivering on that proactively, but we also do respond and react to pieces of work, parliamentary business, other things that are happening. So we have identified 2 areas where we think we can improve and make that easier to use to scrutinise us. Around about how we develop our annual report, and also an impact framework, which I'll just pass over to Gina, who's been leading on this work and could describe in a little bit more detail.
Thank you. So the Commissioner's already described that children and young people determine our priorities, and our strategic plan outlines how we do assess our impact. So we are trying to be transparent about that, but we absolutely recognise that for both MSPs and for children and young people, it can be difficult to know what the indicators of success actually look like in the type of work that we do. So we've started what I'm finding quite an exciting piece of work with our young advisors around how to help build a child-friendly impact framework so that they know if we are doing our job well. And we plan for that to be public, transparent on our website, and actually hope that our subject committee might take that up and use that as a means of scrutinising us as well, because those indicators of success will come directly from children and young people.
That's helpful. Thanks for putting that on the record. Can I just ask you then, and I think we need to be brief because we're quite running out of time, is there areas where you think the scrutiny could be improved? Is there areas where you think that we need to do better, either by the Parliament or the SCB, whatever you feel free to say?
I think just that regularity. So I have had an annual scrutiny session. I'm about to have my second one this year, but I don't believe that did always happen. So I think just being really clear about the regularity of the committee session, and we are hoping that if we can make that clearer about how the work's progressing, that helps the committee as well with the questioning and how that unfolds. And for us, I think it's just about being able to create even stronger ways that children and young people can be really clear. So for us, it's about that external feedback loop that's still in development of not just our young advisors, but young people from other across Scotland and other organisations can be really clear about what are we working on, why and how is that progressing, and have that the opportunity longer term.
Okay, thank you, Convener.
Thank you, Ashregan. Just in the space of scrutiny, I mean, I was part of the Children and Young People's Committee here in the Scottish Parliament when you first came to give your annual report, and on reflection, I sometimes wonder, because you're you're the only commissioner in the Scottish Parliament corporate body in recent times where I've been in a committee. Well, actually, no, the biometrics commissioner came to criminal justice a few weeks ago. But I just wonder if you feel those sessions could be more robust, more probing, because sometimes I think we as MSPs, those sessions are more about hearing from about your work, which is important, but could there be more of a scrutinising approach from MSPs in these sessions?
So I found the session, from my experience, helpful, but I also think it was quite an interesting moment in time because we just published our 4-year strategic plan. So I expect this year the session will have a different flavour, because last year it was about actually how was that formed, why did you draw on these conclusions. I think this year will be more about, well, how, you know, are you doing what you set out in that plan? So I think they'll evolve over time. But I do think there is some responsibility on us as office holders to provide MSPs in advance with the written evidence, the ability to really link, you know, here are the functions, here are the powers, and here's the work that we're delivering, which I think then enable MSPs to consider and form those questions for us. But I have had, you know, genuinely a positive experience of that so far.
Yeah, it's just helpful for our considerations in terms of recommendations to Parliament. Also, we noted that in your helpful written submission, when it came to audit, you reflected that you thought it was a disproportionate requirement with regard to the size of the organisation. Do you want to say a bit more about that?
Sure, yeah. So I absolutely value audit, and I recognise that it's an essential part of, you know, again, that public trust in how I, as accountable officer, am actually managing public money. But the office holders as a group, I think, have had conversations over the past year that I've been a part of where we've just actually looked at the way in which audit happens, the type of recommendations that are allocated to them, and whether there is just, through this committee, an opportunity to just ask those questions. You know, is it of the scale? Are we getting the right type of recommendations? And I thought I could give you 2 examples that would probably help to demonstrate this. So in terms of when I come into the organisation, we now have 1 external audit and 2 internal audits a year. We've got very small corporate services teams, and those give quite a lot of recommendations that are low level for us, but you need to deliver them within a certain amount of time. So personally, I'd like to get internal audit down to once a year, and it's just to free up my team to be able to work on other improvement projects. So at the moment, I'm trying to get IT. You know, we're trying to change that platform because we believe it will be more effective, it will save us money longer term, and we're trying to conserve the time. So as accountable officer and as the head of an organisation, I just feel like I'm juggling these different levels of recommendations with work that I can see that could be developed. And then in terms of the nature of the recommendations, in talking about it with other office holders, some of them are quite generic, not completely tailored to the organisation. And for example, I think we all are consistently asked to do a medium to long-term financial plan. But we do have a 4-year strategic plan. We put a projected budget in that. We're a single source of funding from Scottish Parliament. We can't earn income, you know, so it's just questioning the relevance of that type of recommendation that then comes with the work to deliver on that within an amount of time. And just whether throughout this, is there an opportunity to look at that? But I understand that audit is essential and important as part of that, scrutiny of the organisation.
That's helpful, and I appreciate that may be also relevant to other commissioners and helpful for us in terms of we're likely to hear from Audit Scotland in the weeks ahead. So, just one last question from me, and colleagues, do let me know if you have any further ones. I'm conscious of the specific areas of focus that you've engaged in and the impactful nature of your work. For example, the work around free school meals, and Gina Wilson, I know you've been very involved in that. The work around Scottish football and young people, and what I think is the longest running petition in Scottish Parliament's history. That Nick Hobbs, I know you've been engaged in that, and Commissioner, of course, you're across all of this. Is there anything you want to add? It's almost related to my first question, you know, just about the specific things that you're involved in and the importance of that and the impact that you can make.
So I do have a couple of comments that I would like to make, but it really does go back to where we started about the purpose and the remit of this organisation. And it really is about the fact that Parliament recognised the inherent imbalance for children and young people. So all of those examples that you've given, they're very specific to children and young people. These are about their rights issues and things that affect them. And you recognise that that imbalance of power still exists. That hasn't changed. So you created this office to be able to specifically work on those issues long term. It needs that long term ongoing commitment through commissioner cycles to be able to continue to have the office with that expertise to work on that. As the evidence sessions in the coming weeks unfold, you might hear from other people, potentially academics, that it might be technically possible to take this organisation and merge it with some others. Some people might have opinions, they might think you might find some savings with that. But the main comments I wanted to finish with is, if you find yourself ever considering that, can you please prioritise these questions throughout the inquiry? Is that better for children and young people? Is it in their best interests? Will it progressively realise their rights? The children's sector, children's rights experts and children themselves are not calling for any consideration of a merger. They are not calling for change. They are not calling for reduction. Quite the opposite. This is a model that has delivered really strongly for Scotland, and I really hope this inquiry recognises that. It recognises the fact that some of the other models were proposed based on this model. And I really hope that this committee and this inquiry will support the continuation of this office in its fullest form for children and young people in Scotland.
Thank you. Are there any further things you want to say that you've not had the chance to?
Well, thank you.
Well, thanks for concluding in that way, and thank you to you all for your engagement, your written submissions, your time and your participation today, and for answering our questions. And I will now conclude the public part of our meeting, and as previously agreed by the committee, we now move into private session to consider today's evidence.